Hey Snapflash fam! Botswana's judiciary is back in the spotlight as Justice Mercy Garekwe delivers a game-changing ruling in the Carter Morupisi corruption saga. With allegations of bias and impropriety flying, the stakes couldn't be higher. Will the state's appeal move forward? And what does this mean for Botswana's legal system? Stick around to get the full story. Don't forget to like, share, and subscribe to Snapflash for all the updates on this explosive case and more. In a bold ruling, Justice Mercy Garekwe of Botswana's Court of Appeal rejected Carter Morupisi's application, seeking her recusal from his corruption appeal case.
The applicant has failed to meet the test objectivity, let alone the double reasonability test. He still had the opportunity to bring this application prior to the arguments in the main application, but decided not to. This only points to lack of a genuine apprehension of bias on my part. Moving to consider the Judicial case, which I indeed presided over some years ago, I failed to connect such case with the fact of my presiding over the present application, where my duty is to assess whether or not the respondents have made out a case for an order to have their appeal heard on an expedited basis. The applicant contends that I dismissed his suit and that such decision meant that it was true that he was corrupt as alleged by Sunday Standard. This understanding by the applicant of the decision I made in that case is not supported by the holding in the case. I held inter alia that, and I quote, 1. The defendant's reports on an investigation against the plaintiff of corrupt practices would not lead a reasonable reader to understand and conclude that the plaintiff was guilty of any criminal conduct. The statement was truly made and stated and was subsequently confirmed by criminal charges against him. The article reported on a matter of public interest in respect of the plaintiff, who at the material time was a highly influential figure in Botswana society who held important posts, close quote. I do not know if the applicant's perceived bias comes from the mere fact that I decided that case against him or what. In my many years on the bench, I have not heard of that being a plausible reason for the recusal of a judge. If that were true or allowed, there would be a shortage of judges to adjudicate over many disputes. Litigants generally win some and lose some. Should they call for the recusal of the judges before whom they have lost cases in the past? Additionally, the applicant, if he had any discomfort with my presiding over this current matter based on that case, ought to have acted and moved the recusal application prior to the arguments. He did not and has not explained why in these current proceedings, safe attempting to do so in his replying affidavit. I reject to allow such averments which were known to him, yet he failed to foreshadow them in his founding affidavit. He has thus failed to satisfy all the tests of recusal. On recusal, no reasonable person aware of the Judicial matter, its facts, the evidence, and the decision imposed by the court will apprehend any reasonable bias against me in presiding over the present matter. Lastly, on the CMB matter, the applicant has simply made bold and unsubstantiated allegations once again and has not sought to state the relevance of this case to these proceedings. He was not a party therein. It was his informer, Mr. Wakile, who has prompted the applicant to seek to use this matter to seek my recusal, who was involved in that matter and not the applicant. Applicant contends that he is informed that CMB, which was then under liquidation, had received laundered money from the POPF. It is not clear how a reasonable person could apprehend reasonable bias insofar as this matter is concerned. It is apparent that this application is totally unmerited, a red herring, an abuse of the court and its processes, for were it legitimate, the applicant would have moved it prior to the arguments in the main application, as all the things he complains about, save for one matter, were in his know all along. To act in the manner he has without proper or reasonable justification, smacks of malice and unreasonableness, and it is an attempt at plain delaying tactics on his part. I have been called upon by the respondents to award costs against the applicant on a punitive scale, and considering everything that I have dealt with above, this matter is one where a punitive order for costs is absolutely justified. I therefore proceed to make the following order. A, the application for my recusal is unmerited, an abuse of this court, and is thus dismissed. B, the applicant is ordered to pay costs of this application on attorney and own client scale in favor of the respondents. This is my judgment, my ruling.
Morupisi's legal team, led by Dr. Obonye Jonas, alleged that Justice Garekwe's history with Capital Management Botswana, CMB, a company tied to his corruption charges, made her unfit to preside. They also questioned how Garekwe was impaneled, claiming procedural flaws. In a fiery affidavit, Morupisi accused Garekwe of coaching the Directorate of Public Prosecutions, DPP, during previous hearings. But critics say these claims are vague and unsubstantiated. Representing the state, Advocate Chiamo Rantau welcomed Garekwe's ruling accusing the defense of undermining the judicial process.
The hearing of the appeal to be expedited has succeeded, which means that the appeal against the judgment of the High Court will be heard on an expedited basis by the Court of Appeal. So the court directed that the parties meet with the registrar on Friday, this Friday at 2:30, for purposes of settling the record of appeal. Once the record of appeal has been settled, then the court, the president of the court, will give us directions as to when the appeal will be heard during the January session, which is what the Director of Public Prosecutions and the Attorney General applied for. So that's in essence what the decision is about. No, the Court of Appeal will deal with all the appeal grounds. There are several appeal grounds. The most important, the first one being that the High Court, with respect, did not have jurisdiction or power to issue an order that whose effect is to quash the decision of the Court of Appeal on the sentencing of Mr. Morupisi. One other ground is that one other ground of appeal is that Justice Dr. Kibonang, Judge Dr. Kibonang, should have recused himself. We all know that he refused to recuse himself. That is an issue that the Court of Appeal itself will deal with on the merits when it hears the appeal.
I think I want to know, one of the issues here was that during your meeting in chambers, you seemed uncomfortable and about one of the comments made by the judge. We have heard from many what was happening. Were you uncomfortable at some point by the comments made by the judge in chambers?
As you have seen, I have not filed any affidavit dealing with that. I would not bless such irrelevant allegations with an affidavit, whether no or yes or no. This case was not about me, it's about the parties. I'm not a party. I act in a representative capacity. So allegations of and concerning me, like whether I was cringing or not, I mean, Dr. Jonas is my friend. He's entitled to his view about how he thinks I looked on a particular occasion. I mean, and for me, that was irrelevant. The court has decided that point. I would not revisit it, nor would I want me to become a center of attraction. The case is a very important case. It's way beyond, above us, the attorneys. It is not about us. It is about issues interest of justice, whether or not the decision of the High Court was correct in effectively quashing the decision of the Court of Appeal, employing purportedly employing Section 18 of the Constitution, read with Section 10 of the Constitution. For me, that's the overriding principle. That's the main issue. It's not about personalities. It's about whether or not that decision would lead to legal chaos, as the judge said in her judgment. And obviously, I can't comment on the merits or debate the merits. We have an appeal that is pending. As an attorney, particularly an attorney of record, I'm constrained to commenting on the merits of the appeal. I'm just explaining to, I imagine, the public what the effect of the judgment of the Court of Appeal, today's judgment, is.
I know that she didn't make a ruling on the recusal.
She did not, of course, make a ruling. She made a ruling that the appeal based on the recusal or failure to recuse, or refusal to recuse himself by Dr. Kiwana. He says there are prospects of success on appeal. That's what she said. That is the holding. So she was not called upon today to determine the appeal, but she was called upon today to determine two issues. One, whether or not there are grounds for expediting the appeal, the hearing of the appeal. That's number one. Number two, whether or not the appeal enjoys prospects of success. So she found in our favor on both aspects. One, that there are valid grounds for expediting the appeal, and two, that the appeal should be, two, that there are prospects of success on appeal. So that was really what the judgment was about.
In terms of recusal, what is it that you guys wanted?
The appeal, one of the appeal grounds is that Dr. Kiwana should have recused himself.
Okay.
He refused. So the judge says that that appeal ground has prospects of success.
With Justice Garekwe clearing the way, the COA will now hear the state's appeal during its January session. The DPP aims to reinstate Morupisi's original 7-year prison sentence for corruption and money laundering. At the heart of the matter is whether the High Court had the authority to nullify a COA decision, a move the DPP insists undermines Botswana's legal hierarchy. This high-profile case has sparked national debates about judicial independence, accountability, and fairness. For Morupisi, this ruling is just one chapter in his ongoing legal saga. For Botswana, it's a critical test of the judiciary's ability to navigate complex cases while maintaining public confidence. What do you think, Snapflash fam? Should Morupisi's release stand, or does the state have a point? Drop your thoughts in the comments. And don't forget to like, share, and subscribe for more updates on this unfolding legal drama. Keep questioning and stay informed.